Hello, everybody. It's attorney Laura Sterling, and here we are at Facebook Live. Guess what? I decided I was going to do something a little different today. This is my home office. I don't think I've ever done a live or even a video with the background of what my chaos is or my what do I want to say, my work environment at home is. So this is it. This is just a portion of what you see or what I sit in every day when I'm working or the days I am working from home and how I sit here. And so you do see, whoop, over here, that I do have a television in the background. I never have that on. I have a radio. I have an Alexa. I can't say it because it'll start talking. But I know there's people out there that like to have the music in the background or even the TV in the background when they're working. I can't. I have to have complete silence. So I'm often in here working in complete silence, except for the communication or interaction I have with my staff online. And 99% of the time, I have my doggies in here, but I put my doggies away because you never know. About this time, they get a little anxious for their food. So they get a little restless. Most of the time, they're just passed out. But when it gets to be about this time, they start, moving and grooving and bugging me. And so I'd be doing my live and you'd see a little face coming up here, which probably wouldn't be a bad thing. So, but anyway, so this is, my life. You can't see a lot of it. I have pictures and memorabilia all over the walls. I try to cover every single inch of the wall. I have, of course, my Notre Dame. You probably can't see that in the background, but my great Notre Dame posters. So this is where I live. So where I live on the weekends as well, when I'm working on the weekend, I come in here. It's twofold. It's nice to have an office in your home because you can work from home and you can work on the weekends and you can work till 10 o'clock at night, 3 o'clock in the morning, whatever it may be. But anyway, here I am. So I thought I'd give you a little diversity, a little something different to look at besides, my little Tria and Sterling or Laura Sterling background. So anyway, as you're aware, and I haven't posted the pictures yet, I'm just fresh off of a marathon, 26.2 miles I did on Saturday. That's all I've got to say about it. It was a little traumatizing. I looked, and the last time I did a marathon was 2010, so that was 14 years ago, and I was 14 years younger. This one was a little challenging. It was challenging. It will be my last one. I say that, my famous last words. But they did show a woman who was 75 years old and finished the marathon, Grandma's marathon, by the way, finished Grandma's marathon. And her goal was to do a marathon in every state in the United States. Made me feel like a scrub. But I finished, and I'm going to be posting my pictures probably either today or tomorrow. Before the end of the week, I'll be posting my pictures so you can see the lovely elements that I went through in running this marathon. But it's a fabulous marathon. I've always wanted to do it. It's been around since 1977. This year it's a Boston qualifier. So it was exciting to see all the elite runners. So I'll be posting those pictures. So I want to launch into my live show. So good afternoon, good evening, good morning, wherever you're watching this from. As you know, my name is attorney Laura Sterling of Teruya and Sterling. I wanted to welcome you to my Facebook Live. Now, this is crazy. I've been doing these lives now since 2021. So I have many. There are many that are posted on Facebook, different backgrounds, different hair, different everything. A lot younger, but it's okay. So, but I want to welcome you to my Facebook Live. As you're aware, we cover topics like family, criminal, estate planning, guardianship. We're going to continue to do that. And please, please, please feel free. If you have any questions, you just post them. That's what I'm here for, is to answer your questions. So I want to get going. So just take a little breather, sit down, grab your water. I ran out of bottled water, so I got my Orlando Magic mug that I have my water in. Go Magic. And so make yourself comfortable. If you want to take notes on your iPad or on your computer, whatever it may be, or you're old fashioned and you're going to write everything down, go ahead and write it down. But, when I was thinking, I haven't also given you a little bit of background on me in a while. So you don't really know me except as Laura Sterling, the attorney, but I want to give you a little background on myself. I have a bachelor's degree in social work from a small university up in Minnesota. I have my master's degree in social work from the University of Central Florida here in Orlando. And I should give a shout out to my undergrad, St. Cloud State University in St. Cloud, Minnesota. Go Huskies. And then I'm a licensed clinical social worker here in Florida. And then I went to law school, FAMU, go Rattlers, and obtained my law degree. And I've been practicing in these areas of family, criminal, estate planning, guardianship, and some little other stuff on the side like evictions and property and stuff, but not a lot of that. I mostly focus on the areas I've told you. And I've been doing that since 2005 when I got licensed. So, I was thinking, I'm like, gosh, I haven't really told you all about me lately. So that's just kind of a little bit of my background. I grew up in Duluth, Minnesota, moved down here in 91 as a social worker and just have flourished from there. So I just want to give you a little background. But anyway, let's get started. As you know, it's June 25th. So what does that mean? That means next week, July 4th. Yay! So everybody's going to have fun, right? I noticed my calendar doesn't have as many hearings. This week, they just threw everything at me with hearings because they know next week, oh, everybody takes off for the week, because July 4th, the whole week. So I'm slammed with hearings this week. But next week, I think I only have like one, and it's a nominal one, and it'll probably be canceled anyway. So, but this week we're preparing for July 4th. So everybody's going to the grocery store getting their burgers and their buns and their hot dogs and their ketchup and their mustard. And what else do they get? Well, we like our beer. We do like our beer here in America during our barbecues. We like to have our beer. Seltzers seem to be popular. We get our mixed drinks, all of that kind of stuff. So what does that lead to? It can lead to maybe some tempers, maybe our emotions are a little more emphasized and things happen and we get into arguments. And sometimes those arguments lead to, what do we call? Battery. Battery. That's what we're talking about this month. You see how it took me a while to get there? But battery. What is battery? And as you can see, the battery, it's not a battery that you put into your remote so that you can change a channel. Or the thing on the back of your cell phone that's making it keep its battery life. No, this is a battery. A battery is an intentional strike. So here in Florida, remember, I'm only licensed in the state of Florida. That's it. That's the only state I'm licensed in. So anything that comes out of my mouth legally has to do with the state of Florida. If you're listening to me from another state in the United States, you really need to speak to an attorney. Hey, what are the requirements or what are the elements to prove a battery in the state of Wisconsin? If you're listening in another country, you really need to find out that country's laws and rules in regards to what a battery is. So a simple battery, that's just a basic battery, right? Isn't that sound funny that I call it a basic battery? But that's what it's called in Florida. It's a simple battery. The elements are, it's defined as a person, me. I commit a battery when I intentionally touch or I strike another person without their permission, against their will. So I know in the streets of New York recently, I think it was more towards the beginning of the year, where women were just walking down the streets of New York, and a guy, I don't know if they ever caught this man or anything, would go up and just punch these women in the face, just punch. They had no idea. They were blindsided. You believe you're safe. You're walking down the street and bam, they got smacked, and they would video themselves with these huge, contusions or hematomas on their faces from being punched. That's a battery. They didn't invite that touch. They didn't welcome. They didn't give permission to get smacked in the face like that. Now, when you think of a battery, a lot of times what people think of a battery is an actual closed fist punch, or maybe even an open hand slap. But an intentional touch or strike can be this, can just be that, can be anything that's an unintended, uninvited, not unintended, but uninvited touch. I want to give an example. For example, during COVID, remember how we all wore the mask? God bless. Thank goodness we're not required to wear those anymore. But everybody had the mask on, right? Because we didn't want to spread germs, or we didn't want to catch germs, and somebody's and you didn't want to catch that. So there were lots of incidences and I was talking to my staff, and they actually had incidences in their countries and states and all that, of people intentionally sneezing or coughing on somebody, to oh, I've got COVID, blah, blah. Or even if they didn't, thinking that somehow that was, endangering the person. that's actually a battery. Because if I sneeze on you, I'm not going to mucus, let's call it mucus or stuff from your nose, snot. I'm sorry, I'm just going to use those terms. Hits you from that person, and that wasn't intentional. We're not talking unintentional that somebody achoo and it's an accident, but that could achoo, and that could be considered a battery. And at the time, they were really kind of honing in on that during COVID. Now, whether or not somebody intentionally sneezed, I don't know. That's really going to be up to the state attorney if they feel that they can prosecute based on somebody intentionally sneezing or coughing on you. As a result, putting droplets on you. Now, of course, somebody spitting on you. Yes, spitting on you. That spit lands on you. Yep, that's a battery. That's a battery because that's an uninvited or against their will touching. That's a touching. Your spit. Or it's not just the intentional touching, but intentionally causing bodily harm to another person. So it can be an either or. So the guy not only punching, he's doing the intentional strike, but that's where now sneezing during COVID may have been considered great bodily harm, because what if that person got COVID? What if they got sick? What if they died from COVID because they got it from you? Maybe hard to prove, but I don't know. But just causing bodily harm to another person. It can be something so slight. It can be a scratch. I've had clients that have been arrested or that have gotten somebody else arrested because maybe there was a red mark. So it doesn't necessarily have to be, a hematoma or bleeding. It can be that, if you hit something or whatever, like after my marathon running, my feet were all bruised up. You can just have a bruise, or you can have just a red mark, that red mark on you from the hand, and you can tell how that's done. That's a battery. So a simple battery, the basic battery, and it's actually here in the state of Florida, it's a first-degree misdemeanor. Misdemeanor is a lower crime, but a first degree is a higher in that misdemeanor. You could face up to a year in jail and $1,000 fine. So somebody commits a simple battery when they intentionally touch or strike. So even a touch. I don't want you to touch me. Don't touch me. They continue to touch you. That's uninvited. So an intentional touch or strike another person against their will. I don't want you to touch me. I'm telling you not to touch me. You keep touching me. You need to move away. It's a crime. It's a simple battery. Or intentionally causes bodily harm to that other person. So now that's a simple battery. That's, the touching, the striking, maybe causing some harm to you, but not any great bodily harm or any disfigurement or anything like that. That's a simple battery. So we have different phases of battery here in the state of Florida. Let me take a drink from my Orlando Magic mug. I love the Magic. They're such great guys. Anyway, aggravated battery. What is aggravated battery? Does that mean I'm really mad because I'm aggravated and I commit a battery? Well, you could be possibly very angry. An aggravated battery has the same intentional or knowingly causing, but it meshes off into something else. Great bodily harm, permanent disability, or permanent disfigurement, or uses a deadly weapon. Now, you may say, what's a deadly weapon? Is that a knife? Is that a gun? A deadly weapon could be anything. Anything. It could be a brick. It could be, I have this beautiful little candle here. This candle, this is glass. It's pretty strong. See, it's pretty strong glass. If I use this and I knock you with it, that could be aggravated battery, even though it's not, it smells good. It's not a weapon. It's not a gun. It's not a knife. It's not something that you would usually think of as a weapon, but it could be, because if you knock me on the head with this, I could cause some serious bodily injury. I had a client, and the other person struck that client over the head with a beer bottle. Is that aggravated battery? Of course it is, because a beer bottle being hit over your head, a glass beer bottle being hit over the head, guess what that does? That could open up, that could break your skull, that could cause bleeding, that could cause a traumatic brain injury. It could be anything depending on the force you put into it and how hard that beer bottle. Some of those beer bottles are pretty thick, but it doesn't matter because this can be considered a weapon because of the sheer, it's kind of a little heavy too because of the glass and because of the wax in it. This could cause a lot of injury to somebody. So using a deadly weapon, that could be considered a deadly weapon. Many things have been considered deadly weapons, and I have clients coming to me and saying, oh, but it's not. Look at it, it's a candle. It's not a deadly weapon. But it could, because it could cause serious bodily harm. So a person commits an aggravated battery if the person who was a victim of the battery was pregnant. So there's also that enhancement if the victim of the aggravated battery was pregnant at the time, or the aggressor. I'm going to call the aggressor the person who commits the battery, and the victim is the one who's getting the battery, receiving the battery. If that aggressor should have known they were pregnant or knew they were pregnant and considered that, and committed the battery anyway. Now, aggravated battery is it's a felony, and it's actually a higher felony. It's a second degree. As you know, we have the 3 levels here of felonies. I'm not counting capital felony or anything, or life felony. There's a first degree felony. That's the lowest felony. There's a second degree felony. That's the next step. And then there's a third degree, which is the higher of the 3 felonies. An aggravated battery is actually a felony of the second degree. So you're bypassing that first and going directly to the second. And the reason why is because you're not using your hands anymore. Even though your hands could be considered a deadly weapon, you're now using something. You're taking something and using it against that person. And that's why it's bumped up to that second degree felony. And of course, a second degree felony is punishable by up to 15 years in prison and a $15,000 fine. Now, when I'm giving you what I want to say, the punishment by saying, second degree felony is punishable by up to 15 years in prison, I'm not saying you're automatically going to get that. That's your maximum exposure. That's what I tell my clients. I go, your maximum exposure, let's say it's an aggravated battery, is your maximum exposure at a second degree felony is 15 years in prison and a $15,000 fine. And how I explain it to my clients is I say, if you were to go to trial and you lose, the judge has a discretion of maximum up to 15 years in prison. Of course, you can always do a plea arrangement or a plea agreement or anything like that. We'll talk about that a little later, but that's your maximum exposure when you're dealing with an aggravated felony. And as I said, with the simple battery, that's a first degree misdemeanor. Your maximum exposure is 1 year in jail and a $1,000 fine. Now, mind you, I want to explain something to you. In Florida, if you're spending 365 days and less, you've been sentenced to that or you're going to serve that. If you're 365 and below, so anywhere between 1 day and 365 days in jail, you're staying in jail. They don't ship you off to prison. If you're serving 365 days plus 1, and anything above 365, that's when they'll send you to prison. That's when you're transferred to a receiving facility, and then you go to prison to serve your time. Jail is only for somebody that's 365 and below. So I just want to point that out to you. So it kind of gives more perspective, because people always come to me and say, you prison, jail, and there's a difference. Jail is 361 to 365. Prison is 365 and above. So anything more than that. Okay, so that's an aggravated battery. So what is a felony battery? So a felony battery is kind of similar to an aggravated battery, right? We commit a felony battery if you actually and intentionally strike another person against the will of the other, just like all the other batteries, but it causes great bodily harm, permanent disability. What would that be? Let's say you broke somebody's leg. That's a battery. You broke somebody's leg. You intentionally broke their leg. They can no longer walk. Permanent disability or permanent disfigurement. You threw something on them. You threw acid on them and it burned their face. That's a permanent disfigurement. Now, it's funny because now I guess the acid could be considered a deadly weapon, but a permanent disfigurement where you punch them so many times, you've now disfigured their face. So that would be more of a felony battery. Felony battery comes right in under the aggravated battery because you're not using that deadly weapon. You're simply using your hands, but our hands could be deadly weapons, right? But they're just saying causes great bodily harm, permanent disability, and permanent disfigurement. So that is actually one less. That's a third degree felony. Remember, we started the third degree, second degree, first degree. So the third degree is the lowest of the felonies. So that's punishable maximum exposure up to 5 years in prison and a $5,000 fine. So that's what a felony battery is. So, oh, hi, Fabian. How are you? Let me see. I want to know how I can protect myself from someone who is threatening me with harm. Wow, Fabian, that's a good question. Let me kind of jump. I'm going to jump ahead a little bit to be able to answer your question, and then I'm going to talk about it in more detail, just so I can get your question answered, because I know that's an excellent question and a very good question. We have something in the state of Florida called protective injunctions. And so, or protective orders. And those protective orders say, I'm in fear for my life. I'm in fear for my safety, for my life, of me, maybe my children as well. This person is threatening me. They told me they're going to kill me. They're going to do all this kind of stuff. Or maybe they're stalking me. They're following me. They're making sure they know where I am. They're always there. They come to my job. They're outside my house. They call me. There's even the cyber stalking that could be used in that as well. That's something new within the last, 10 years? I've been practicing 20 years. So a protective injunction is something that's completed by the victim. Again, I'm going to use victim and aggressor. The victim saying what the aggressor is doing, they can fill that out. It goes in front of a judge. A judge just reads it. They just simply do this, read it. They don't ask any questions. There's nobody around them. The aggressor's not in front of them. The victim's not in front of them. They strictly go off what the victim put in their paperwork. And they can either grant a temporary one, and then they got to call everybody in for a hearing, because the aggressor has to have due process and has to say, hey, wait a minute, I didn't do anything, and here's why I didn't, or here's how I didn't, or here I want to prove I can show you I didn't do it. Or the judge just denies it, saying there's not enough here, or the judge denies the temporary injunction, but says, y'all need to come in because I need to hear for myself what's going on. And then I'll decide whether or not I'm going to grant it or deny it. So excellent question, Fabian. We'll get into that a little more detail as we get go further on. But that's a good question because a lot of people don't know about that. Anyway, with batteries, there's aggravating factors. In criminal cases, there's always going to be aggravating factors. What makes the charge worse than it is? So what brings it up a level, or what makes it, what brings it up to the next level? So some aggravating factors with batteries is the use of a weapon. What weapon was used? Did you use a weapon? How did you use it? How much injury did it cause? The extent of those injuries inflicted. The relationship of the victim and the aggressor. The aggressor's past criminal history. And all of that can influence the severity of the penalties. We have here in the state of Florida a score sheet. And in that score sheet, there's certain numbers that are given, scores that are given to certain crimes. And so if you have an aggravated battery, but your criminal history, you have an extensive criminal history, that's going to be pointed out in this score sheet, and you're going to score higher. You're going to score at the end, potentially some prison time. Was there injury points? How bad were the injuries that victim encountered? There's victim impact points, there's victim injury points that are added into that, and at the end you do your mathematical equation and out pops a number. And not to say again that you'll get that, but that's your exposure at that point. So generally when I do a negotiated plea, I get that score sheet, and then I also get the negotiated plea and I hand them to the judge directly so the judge can see that. And I also go over the score sheet with my clients so they're fully informed about, hey, if you went to trial and you were found guilty, this is the maximum exposure that you could look at based on all of what's in the score sheet. So anyway, so it's always good. I mean, in criminal court, the nice thing is, hey, it's a good thing to get an attorney because we're talking about your civil rights. We're talking about your rights. If you can't afford an attorney, and I hope that you would be able to afford an attorney, but if you can't, there's a public defender. Public defenders are very good attorneys. They're a little overwhelmed, but they're very good attorneys. They're in trial all the time. So, but we're also here to help you. So, anyway, okay. So, how I talked about one of the aggravating factors was the relationship between the aggressor and the victim. I've gotten a lot of cases. I shouldn't say I've gotten a lot of cases. I've gotten only a few cases where there wasn't a relationship, a prior relationship between the aggressor and the victim. Only very few cases. There seems to be a lot of batteries going on with people that have a relationship. And I'm talking about any relationship. I'm talking about family members, brothers, sisters, cousins, aunts, uncles, mom, dads. Then we talk about the intimate relationship, boyfriend, girlfriend, life partner, wife, husband, those kind of things. Those are what we call here in the state of Florida battery/domestic violence. Why do we add the domestic violence? Because that word domestic means family, familiar, domestic. So battery, domestic violence means the intentional touching or striking, like we've spoken about, against somebody's will, where there's a relationship there. Like I said, mother, cousin, brother, sister, boyfriend, girlfriend, life partner, spouse, whoever it may be. But that's where that battery domestic violence comes in. Again, battery domestic violence fits into that category of a first degree misdemeanor, the most severe of the misdemeanors, with the lower ones here in Florida. There's a maximum exposure there of 1 year in jail and $1,000 fine. And like I said, everything is the same except we add that extra language, family or household member. So it could be boyfriend, girlfriend, and you've lived together at one point. Did you live? So are you related by blood? Did you live together at any point? We have a lot of boyfriend, girlfriends, they live together, they get in a fight. That's a battery domestic violence. So anybody that maybe has children together, are married, are living together, cohabitating, as we like to call it, that's a battery domestic violence when battery is committed on that person who you live with. And I have had it in the past where they could no longer be together. They could no longer, boyfriend, girlfriend, they live together, they break up, and they no longer are together. And then a year later, I don't know what happens, but they come back and all of a sudden they get in a fight. That could be considered a battery domestic violence because at one point they did live together. So they had that relationship at one time. And I actually had a case like that where they did charge it like that. And I'm like, are you kidding me? Like they haven't been together forever. But because they were at one point, they were charged with that. Now, again, I spoke about, the enhancements. So an enhancement in a battery domestic violence, meaning it brings it up to the next level, potentially to a felony, is Committing a battery against a family or household member can lead to that enhanced penalty from a standard battery, and it may include mandatory arrest or a no contact order. Let me tell you a little secret what happens when you get arrested on a battery domestic violence. So there's a battery domestic violence going on. Somebody calls the police, whoever it may be, in reference to this no contact order and jail time, all that. So maybe the neighbor calls the police. I get that a lot. My clients, oh, nobody, she didn't call the police. I didn't call the police, but the neighbor did because the neighbor saw it or the neighbor heard it. And so they called the police. The police show up and they see marks. They see red marks, so they see scratch, whatever it may be, and they arrest you. Let's say they arrest the woman because the man has scratches and he's got red marks and everything. So they arrest the woman. That woman cannot be released. So she can't be arrested, put in the jail, pay a bond, and get out right away, which sometimes you can do with most charges. You know, okay, how much is my bond? 500. Okay, here you go. See ya. And you're out within hours. No, 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 no. What they do here in Florida is they make you cool down. You got to cool down. So if you're arrested at 10 o'clock at night, you're not getting out until the next day. If you're arrested in the afternoon, you potentially are not getting out till the next day. They want you to cool down. They want you to cool. So then oh, I think I had a little glip there. So I think my kind of went. Okay, we'll see how far we get. Okay, so battery domestic violence, what they do is they arrest, want you to cool down. They want it to cool down. So you have to sit there. Believe me, I've had clients call my cell phone. The ones that do have my cell phone number have called my cell phone from jail at 2 a.m. It's a collect call. I don't accept it, but that makes me know, oh no, they're in jail. So then I can look and see what they're there. Call me one time at 2 a.m. She wanted to get out. They're not letting her out. You're not getting out. You're not getting a bond until the next day when you've done a first appearance. So that's what they make you do. Now, when you get arrested and when they do have a first appearance and you do pay the bond, there's a no contact order. You cannot have contact with the victim. So that woman who was the aggressor, who started the fight and who got arrested, can go nowhere near the victim. Nowhere near. Nowhere near. You have to be a no contact. And if you violate that no contact, let's say the boyfriend or whomever calls, oh, come, I'm so sorry. I'm so sorry that, it was my fault. Oh, come home and be with me. And she, oh, yay, and run home and hug. He can call the police and say, she's here. She's violating the no contact. I have seen it where, and I've done it before, gone in and requested the court to do a contact order. Maybe there's children involved and they need to communicate regarding the children. Then the court would potentially grant contact with some criteria. So I've actually seen a case. I didn't argue the case, but I saw another attorney argue the case. The husband was arrested for battery, domestic violence against his wife. There was a no contact order. He was given no bond for whatever reason. I don't know what the details were, but the attorney brought his wife in and she testified. Apparently he punched her and knocked out her front tooth or both her teeth. I don't remember. And she wanted him to come home. And the judge was reading the police report and saw where he punched her tooth out. And he said, but he punched her tooth out. And the wife said, oh, it was okay, Your Honor. It was loose anyway. I just had to shut my eyes and just kind of take a deep breath because, it's a battery. It's a battery. So hopefully, everything went okay and she was fine. And they were getting counseling, they said, at the church and all that kind of stuff. So hopefully everything went fine. But it could require, well, it's going to be a mandatory arrest. They'll bring you in. They'll keep you for, your first appearance. There'll be a no contact order unless you ask for, some contact, maybe no hostile contact. That's one that we ask for a lot of times when there's, and then there may be something called a batterer's intervention program. So anyway, it's in domestic violence cases are treated seriously in these jurisdictions. That's a loved one. That's your boyfriend. That's your girlfriend, whatever it may be. And so they're treated pretty seriously. And due to the potential for recurring abuse and the emphasis on protecting vulnerable individuals, that's why they have it. So, when you're in that relationship, when you're in that marriage or partnership or whatever, sometimes somebody is not only battering physically, but psychologically. And so, the state of Florida at least is wanting to protect that person from that. And so maybe a lot of times they don't call the police, or they're afraid to call the police because they're so threatened. So that's why they have the enhancements on there of a violence battery as well. So anyway, but how do we, I've represented people that the aggressor that has the criminal charges against them, and I've also represented the victim. And how I represent the victim is let me put this on Do Not Disturb. How I represent the victim is by what Fabian asked about a protective injunction. An injunction court order is sometimes called a restraining order, or I call it some people tell me I want a protective order, restraining order, whatever it may be. It directs a person not to have any contact with you. So if I go in and I say, I want a protective injunction against stalking, so I have to prove the stalking, or if it's sexual violence, it could be anything, or dating violence, anything like that. So that's what I'm going in and I'm asking. So how does that happen? So what I do is I go into court, and I'm going in by myself, or I have somebody with me that helps me, or if I don't speak English, they'll have people there that have the different languages that can help you fill it out. They have advocates there. It costs absolutely nothing to complete this protective injunction. So you sit down, it's got a bunch of questions. You need to describe in detail what has happened, why you're afraid, why you're in fear for your life, how this person has committed sexual violence, how they're stalking you, how the repeat violence. You have to go into detail, because understand, this is going to a judge. And the judges, you're not going in front of the judge. You're not going with that piece of paper, with that application to the judge. So the judge can't ask you any questions. So the judge is specifically going off of that document. So you want to be as specific, want to be don't be general, you want dates, all of that kind of stuff. So I always tell people, take your time in completing it. If I've been hired to do it, I take my time with my client. Okay, what was the date? You don't have to know like June 10th, but June 2023. That's good to show the court, okay, there is a pattern here that shows that violence. So you complete all of that, or you have somebody help you complete it, because maybe you don't speak the language, and they can write it for you. Then what happens is you hand it to the clerk. The clerk doesn't charge anything for you doing it. Generally when you file a divorce or something, you got to pay a filing fee. With a protective injunction or restraining order, there's no filing fee. You hand it to the clerk takes it, logs it in, but it's not public. It's not public. They bring it up to the judge reads it. The judge decides, okay, I'm granting it. Let's say the judge says, I'm granting this petition for a protective injunction against sexual violence. I'm granting it. So the judge has to set a hearing within days, 1/5 of the day they sign it, because the statute says within 15 days of the granting of that temporary injunction, there needs to be a hearing. Because again, the aggressor has to have due process rights to defend himself against that petition. Because again, it's just one thing. It's them who's putting it down. The aggressor has had no chance to to say their case. So the court sets a hearing. Doesn't matter if you're available or not, sets a hearing. They send it out, and usually a deputy will serve it to the aggressor. Now, if the deputy can't get the aggressor served for whatever reason, you're still going to appear for the hearing. If you appear as a victim, the court will continue it to allow the sheriff more time to serve that person. Again, there's only going to be a certain amount of time that the court will allow for service. If they just cannot get service, they may dismiss the petition, but they have service. And the person, the aggressor, cannot violate that injunction until they're served with it. So if they have contact with the victim, I'm pretending like I'm having contact, I'm opening the door. If they have contact with that victim before they're served, they can't violate because they don't know about this, because again, the case is not public. It's not public until that aggressor is served. So I can't go on right now and say, oh, I got to look at my case. I can't until the aggressor has been served with it. So then the court sets the hearing. Let's say the aggressor is served. They show up for a hearing. The victim will be asked by the judge, do you wish to proceed with this injunction? Yes. If they say yes, then the court proceeds to talk about what's in the petition, how they're in fear of life, all of that kind of stuff. And then the judge will turn to the aggressor and say, okay, are you facing any criminal charges? Now, when I go in with a client and there's some potential that there may be a criminal case, I'm going to advise my client not to say anything, because guess what? The person recorded. So if there's an active criminal case because of this injunction is a result of an incident that now my client has criminal charges, or I fear that there is potentially going to be criminal charges down the road, I don't want my client to talk. And sometimes they convince your client not to talk, because anything they say can be used against them in the criminal case. So lots of people think, oh, well, no, I'll be fine. I'm just going to tell it like it is, and I'm going to tell the truth. But you don't know what you're going to say. You don't know what's going to come out of your mouth. And that is recorded. And a lot of times in the courtroom for the protective injunction, there's a representative state attorney in the back, and they're listening. And so they can take whatever you say, get that recording, and use it against you. So I always advise the judge, if I'm representing that person, if you're not represented, the judge will ask you, are there any criminal charges pending? If you say yes, the judge will go through that soliloquy with you saying, do you understand that you have the right to remain silent? Do you understand that anything you say can and will be used against you in that criminal case? And if you still decide to testify, anything you say can be used. Like I said, I convinced my client, just don't say anything. Chances are at that point, then the injunction will be granted. But again, a protective injunction is a civil criminal. Hi, Candela. What happens if someone gets charged with battery more than one time? Is the punishment the same each time they are charged? Excellent question, Candela. Very good. Unfortunately, you can't, the more you get charged, the state attorney can enhance it. They can make it into a felony battery. They can enhance it. So if you get one battery, a simple battery, like I said, a simple battery, the misdemeanor, 1 year in jail, $1,000 fine, battery, domestic violence, you got the one time, that is misdemeanor, first degree misdemeanor. You get a subsequent one, you get a second one, they can enhance it to a felony. Now, I can say in any of my cases where there's been more than one battery, they haven't charged it as a felony yet. My second ones, I haven't. I don't know if I've had any more where they've had more than 2 batteries, but they can. After the first one, they can charge it and bring it up to a felony. They can enhance it because they're trying to deter you from doing it. They're trying to deter you from doing it. So excellent question. So, okay. All right. So we're still on the injunction. So, okay. So the injunction hearing, you've decided not to testify because you're afraid there might be some criminal charges coming down the pike. And I've had that happen. And I've explained to my client, I usually tell the judge myself, they don't want to testify. They are electing for their right to remain silent. And then what I do, I'm tricky. I'm tricky though. A lot of times what I'll do is, if my client agrees to that and we're good, then if there's children involved or anything, then I can spend the time going, he did the right to remain silent, but we want to deal with the children, because then that cuts time down and the judge is more apt to listen to that after, rather than during an hour long deal with the children. How can we do some time sharing here? Because right now my client hasn't seen the kids. The violence wasn't against the kids. It was only against mom or dad. And so then I try to work that out for my clients so there can be some kind of time sharing with the children. And maybe they can pick out a third party to do the exchange rather than the or any kind of nonviolent or public place where they can do drop off where the other party feels safe. So, but anyway, so the protective injunction granted, it'll usually be granted. I've had only a few that have been granted indefinitely, meaning until further order of the court. This is in effect until further order of the court. So it has to be somehow brought to court and dissolved at some point, or it gives a deadline for 1 year. So, whatever date the judge signs it, July 1st, 2024, it expires July 1st, 2025. Then at that point, there's no more protective injunction or no more restraining order. But I always tell my clients, listen, I know it's expired. I know that, but let's try to, stay away, because you don't want this to come back again. Now, as it's getting closer to that deadline of it expiring, you can always extension. Hey, I need an extension on this protective order. But you can't just ask it because it's better to do, or you're fearful that something may happen. When you do that extension, there has to be an incident. There has to be something that happened that provokes you to come in and ask for an extension. Me, or he's done this, or she's done that, or something that brings you forward to ask for the extension. You can't just fear that something may happen. Well, has anything happened in the year? No. I had same thing. Girlfriend filed it against my client, filed the protective injunction. The protective injunction was granted, I think, only for 6 months. As it got closer to the 6 months, she filed an extension. No reason. My client didn't talk to her, didn't go near her, exchanged the kids, fine and dandy, no incidences, no nothing. And I was all set with my case law and my argument, and I was going to trash this and I was going to crush this. The judge took my thunder away, because she said to the victim, what is going to precipitate me extending this? Can't just extend it to extend it. Maybe the criminal case is still ongoing. That might be a reason to extend it. But generally in the criminal case, there's a no contact order anyway. So, but anyway, the judge denied her request for an extension because there was no need. My client really didn't want anything to do with her, was really just wanting to deal with the children. So, and we dealt with the children in a different case. So that's a protective injunction. There's a way that once a criminal case is done and the no contact order is done, that protective injunction sometimes can go even longer than the no contact order. Now, if the judge denies that protective injunction at the hearing, and there's not a no contact, it's a double negative, not a no contact in place, then there's nothing. But again, I always tell my client, if they're the aggressor, stay away. Stay away. You don't want this again. Stay away. Is there any way that you can move out or do something? Have to get involved with this again. So, because I'm telling you, a lot of times with relationships, with that blood relationship or that intimate relationship, I tell you, things happen, things get heated and stuff happens. And then, you're arrested for a battery, a domestic violence, and then you've got a protective injunction. And again, a protective injunction is a civil case. It's not a criminal matter. The only time it becomes a criminal matter, if you violate it. If it says you have to stay 500 feet from your house and you go 500, you go at the front door, you're sitting outside in the driveway, she could call the police. You're violated, you're now arrested, and you're in jail. And that's a whole separate criminal charge, violation of a protective injunction, a battery, domestic violence, and a violation of protective injunction. I've had them, I've done them, I've dealt with them. Anyway, that's how we battery in the state of Florida. I like to talk about these issues during the summer because we're a little more relaxed. Most of us are outside, I hope, enjoying the weather. We're at the lake, we're at the pool, at a friend's house, at a barbecue. Stuff, alcohol starts flowing and you're out in the sun and that alcohol goes to your head and things start to happen. So I want you to know, if things start to happen and you end up arrested, we're here for you. We're here to help you. We're here to help you with your criminal charge. We're here if you're the victim as well, to help you with potentially a protective injunction or holding your hand through that issue of that criminal charge against the other person and making sure you're protected. So I'm so glad that you were able to join me. I hope that little stinker there didn't knock me out too much. I saw the circle of death. Luckily, we're back on, so I'm glad that we're able to keep together. Please, 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 if you have any questions, give me a call. There's my number. I'm here to help you here in the state of Florida. I hope that you have a wonderful and restful and non-arresting 4th of July. But if you do, something happens, we're here for you. And know that next month, the month of July, I'm going to talk about driving under the influence. That's something I like to do during the summer as well, is talk about that and the different types of driving under the influence and the punishments. So I look forward to seeing you in July, and have a great 4th.